We're going to touch on internal mechanisms that shareholders have through shareholder agreements. And we're going to mention issues that happen with those shareholder agreements that go wrong and how to address them in different ways and the benefits of different ways and go into detail a little bit on each of them. So I have a set of notes here. That's what I'm looking at because I don't see the slides that you guys are looking at. So common corporate structures is the first point that I'd like to touch on. Corporations can be set up in different ways. There are sole proprietorships, partnerships, corporations. There are nonprofits, professional corps. A sole proprietorship is generally how everyone starts. It is what an independent contractor is. It's having an agreement directly with a supplier, and you're providing services to that person directly, generally. Sole proprietors don't generally have employees. When you get to the employee stage, you get more to the corporation level. But sole proprietorship are the most common way that folks conduct business. The most common sort of business transactions go also from sole proprietorships. Partnerships is interesting because partnerships can be between two different people. So two sole proprietors in a way, or two corporations. It is a joint venture in a way of two different entities or more. And those entities could be made of any of the following. Corporations are essentially often owned by one shareholder who's the owner, but often could be more shareholders too. Companies, when they get to a certain size, they have more shareholders, and that's where things need to be codified a bit more in a shareholder agreement between them that would set out important issues, and we're going to get to it in the following stages. Now, for profits, similar to corporations, there are just no dividends paid at the end of the year, and instead they're reinvested back into the corporation. Professional corps are also very similar, but they're for generally lawyers, accountants, and certain industries only. Corporations can be set up in two different fields, let me call them, or under two different regulations, really. They could either be federally regulated or provincially regulated. A federally regulated business is generally a business that is within the telecom industry, within the train and commute, sort of that is cross-border, so trains. It could be banks and aerospace. Generally, most of the corporations that you see day to day are provincially regulated, and yours would be as such, unless you have a trucking business, for example. So that would be federally regulated. So let's get to the shareholder agreement. Generally, what is it? What does it have in it? What to look for? Shareholder agreements generally define the roles between the shareholders, so who should be doing what, and to what extent reporting would also work. There are many things that are included in a shareholder agreement. So responsibility being aside, roles, the valuation method of how you got to the value of the shares. So is it a multiple of revenue? Is it a multiple of EBITDA? There are different ways that one can get to a formula that would be used for that class of shares when you are adding shareholders. And also the transfer restrictions between the shares. So whether an owner or a majority shareholder can create a new set of class of shares, before offering them to existing shareholders, as opposed to not. That is one area where litigation happens quite a bit. Other clauses that you hear about in a shareholder agreement, well, you read in a shareholder agreement or you hear about during cocktail hour, is a shotgun clause. One of them is that drag along. So let's get into the shotgun clause. The shotgun clause is a clause that offers protection for shareholders, whether they're minority shareholders or majority shareholders, Generally, it is used between two shareholders when they just don't agree. And what happens is one of the shareholders will offer to sell their shares at a certain value. And the alternate of that same offer would also then offer to buy the shares. If the other party doesn't agree to buy your shares, you'll then agree to buy them at the same value or valued at the same, using the same formula. Obviously, if you own 30% and partner owns 70%, then the numbers would have to match that percentage. But often a shotgun clause is a great way to make sure that what you offer is fair, because that is the same rate that you'll have to pay for it anyway. So it is a way to get out of agreements that you find yourself no longer with a meeting of the minds with your partner when you're going through them. Drag along rights are minority shareholders' rights, which allow them to essentially join in with the majority shareholders if the majority shareholders are selling shares, or rather selling the business to a third party. So if a majority, a 90% owner decides to sell the business, this would allow the minority shareholder to also sell that 10% as part of the same sale to that third party purchaser. Now, if we were to, there are tag-along rights too. It allows minority shareholders to join the majority. Also, there are, so the drag-along rights, actually, let me correct that. What I mentioned was the tag-along rights. The tag-along rights is what forces, or rather allows minority shareholders to join in with the majority. The drag-along actually drags along the minority and to not stop the sale from a business. So the drag-along rights protects more the majority in the event of a sale, and the tag-along protects more the minority in a sale to tag along their rights with them. Forgive me about that. Right of first refusal is the right to allow a shareholder to purchase a set of shares that are for sale before them being offered to a third party. Buy-sell agreement, similar to shotgun clause. I won't get into it. Oppression remedy is a big way. Well, actually, before I get into the oppression remedy, so generally these are the rights offered and agreed to within a shareholder agreement. Now, what happens after that is if there's a disagreement on what has happened throughout, there are different mechanisms allowing the shareholders to go through a process of whether it's redeeming their shares or ensuring fairness in how their shares are valued and treated. Oppression is one of those remedies. So the oppression remedy allows a shareholder to protect their own interests by suing the corporation. So they would say that we are being oppressed by the way we are treated. So whether it's our dividend policy is not being applied how we've agreed to, so we're not receiving our dividends. If there's division of assets being sold by the corporation that they don't agree on, so a shareholder can bring an oppression remedy claim to then sue the corporation for their own rights and get them back. The way this is different from a derivative action is a derivative action allows the shareholder to sue the directors on behalf of the corporation. So it is to reinstate the rights of the corporation as opposed to reinstating their own personal rights with it. Oppression remedies are quite common. They're the first sort of default claim that one goes to because it is easier to advance than a derivative action, which requires, notice. An oppression claim is also good because a judge has quite a lot of freedom to order whatever they want. So they can liquidate shares, they could order directors off the board, they can really do a slew of remedies that they have available to them in case they find that a shareholder was oppressed from a sale or something. Derivative action, we talked about it, generally more in misappropriation of funds, fiduciary duty, sort of claims more attached to the directors themselves who have essentially done something they should not have in the eyes of the shareholder. These are generally two claims under the Ontario Business Corporations Act and the Canadian Business Corporations Act. Now, what is also available are motions, injunctions. What is an injunction? An injunction is a motion that is brought that stops a party on the other side from doing something, or from whether it forces them to do something or stops them from doing something. Injunctions can be in three different categories, so interlocutory, permanent, and mandatory. Interlocutory means it is an interim injunction, meaning pending something else that happens, and that is often what one sees. Permanent injunctions is one that would require an order to be made, obviously, to be carried on permanent basis. But that is to be sought after a full hearing. A mandatory injunction is specific to a certain act and not actually a final one to after the disposal of the hearing after a permanent injunction. Injunctions are great. They're also scary for parties on the other side to receive because it obviously stops them in their track. But also injunctions are and could be dangerous for you if you're advancing one, because what will happen is if you do win an injunction, the other party will start quantifying the amount of damages that they've lost from the date that you've gotten your injunction until the date that this injunction would then expire. So if you get an injunction, to stop a party, your partner, from non-compete, and it's found to be in 2 years or in a year, that period, that non-compete was not enforceable, then you may owe your partner the amount of money that you stop them from earning using your injunction. So I'll say that again. If you think your partner is doing something wrong and you say, Chris, we need to stop them from doing it, we need to file an injunction, we'll go file an injunction if that's the smart thing to do. And then we'll stop them from doing something for a certain period. For 6 months, you stop your partner from getting another job, for example, in a certain industry. If it happens that after we stop them, a year passes and the trial itself is done, and now we know that this injunction that happened, we can now decide, should it have been final? Should it have been rendered? Should that non-compete been enforced or not enforced? That can only be decided sometimes after the fact, and when it's decided long after the fact, the person who was subject to the injunction in the first instance can come back and get their money potentially that they lost because of that injunction itself. Often many of these issues are settled and they're negotiated, and often litigation lawyers don't necessarily litigate all the way to trial. Many instances of settlement happen throughout, and these are possibilities. And sometimes you could split what one is arguing about and be creative in minimizing litigation. So injunctions can be used for trade secrets, non-competes, intellectual property use, using your book of business, anything that you think they would not have had access to had they not worked with you and because of your work together. Arbitrations. That's an interesting one. And it's also a tricky one. The reason it's tricky is because, well, frankly, just like a superior court, it is subject to people. And there's a human there. The human is an arbitrator versus being a judge. A judge could wake up one day and have had a dream of someone who looks like you and just really be angry at you that day for really no reason. There is an element of uncertainty that one cannot predict with litigation. So that's whether it's through superior court or through arbitration. Now, what is arbitration? Arbitration is a form of proceedings that is similar to a trial and regular court proceedings, but it is more private and it's confidential, it's speedier. It's often costly in the short run, but you would end up essentially paying the same amount of money potentially if you were to go through the superior court route. But arbitrations tend to be faster. Confidentiality is one of the biggest benefits. One of the negatives of arbitrations is that, frankly, just like courts and judges and lawyers, everyone ends up knowing everyone after a while of doing it. Arbitrations are a bit more like that. So choosing the arbitrator during the process. So if your shareholder agreement mandates that you go through arbitration as opposed to going through superior court, one of the biggest first steps and trickiest first steps is agreeing to an arbitrator with the opposing side, and also picking an arbitrator that you actually trust would be fair, would be flexible if needed, or not flexible if too much flexibility has been taken advantage of. Arbitrations can be more beneficial simply because they're faster and they're more private. So documents aren't filed with courts and nothing really can be searched through the court system. If I'm given the choice to go through arbitration or superior court, I would choose superior court. It is not all too much slower, but there are more instances of negotiation. Whereas when you're on an arbitration track, you're a bit forced to follow a bit of a timeline that sometimes can be arbitrary. Whereas in superior court, you're allowed to be flexible with the rules as long as you're reasonable with them and you're reasonable with opposing counsel. So that tends to be my preference. But if you're working with an arbitrator that you trust will be fair, then arbitrators can definitely be a good way to bypass the weight of superior court. It's a form of dispute resolution. That's it about for arbitrations. The next step is going to be litigation, which often is where 95 of issues end up that we discussed today. Litigation, as you know, is the court process of taking a matter from you feeling that you were aggrieved all the way to a judge for the judge to decide if you were in fact, lost damages, incurred damages in any way. So litigation starts with a statement of claim. Now, the litigation process, when we talk about it technically, it starts with a statement of claim. Many issues could be resolved pre-litigation. So when you hire a lawyer, or if you hire a lawyer, not everything needs to go to court right away. So one often can start with a demand letter. It's often telling someone you have 7 days to pay us because you did A, B, C, D to us. And if you don't pay it within 7 days, we're going to sue you. That can be done, and that should be done to allow for a conversation to happen. If that happens, then, and there are fair offers being exchanged, then litigation doesn't really need to happen. you don't need to start a statement of claim. Now, what is a statement of claim? A statement of claim is the first official document that you file with the courts and you serve on the opposing side, outlining what your claim is, how your rights have been violated, how your company has lost business because of your partner doing A, B, C, D, for example, and you outline all the facts that you need to outline without outlining the evidence. But that's more of a technical issue for lawyers, really, on how to draft. You plead your case and you file the statement of claim. That is the first document that tells even the judge what you are seeking from the court and why you're seeking it. What happens after that, the other side has 20 days to respond to file a statement of defense. Within 20 days, they can, before filing a statement of defense, they could file what is called a notice of intent to defend, which gives them an extra 10 days, 30 days. The interesting thing about the court system and the rules of professional conduct is if an opposing side reaches out to us and says, hey, I need 10 more days because I haven't had the chance to finalize ABC because my daughter is sick, we kind of have to agree. Which obviously, our clients don't always like, and I get it. If we feel there's an abuse, if every time someone's sick, then obviously we don't have to extend our professional obligation there. But the rules are meant to outline timelines. They're not necessarily meant to be set in stone. That said, within 20 days or 30 days, a statement of defense is filed. The statement of defense will outline everything wrong with the statement of claim and how the plaintiffs are wrong, and it's sent back. Now, many things could happen. A litigation lawyer can be, fortunately or unfortunately, very creative in delaying steps or in making things a bit harder than they need to be. So that 20 days and 30 days that we mentioned could actually be extended to about a year. And the way one could do that is if they require more information, so they demand particulars from a statement of claim. It is a tactic, and often lawyers see through it, and you don't want to do it, but there are ways for you to require more information from the plaintiff if you don't think you can defend properly. So that would then delay the defense more if you think you need more information. After the defense, a reply is due. A reply is not mandatory, but it often is the chance of the plaintiff to say how, or to outline how the defense is inaccurate for the record and file it. What happens after that is strategically important. After the pleadings close, meaning after the statement of claim, defense, and reply is filed, two things could happen. You either, the parties go through mediation or they go through discoveries. There are tactical reasons why one should choose one over the other, but first I'll define them quickly. Mediation is a half-day or one-day meeting in separate rooms, often with the help of a mediator who shuttles back and forth between rooms and bringing both parties' cases closer together by essentially telling every party how their case is weak and how they would benefit from settling. That's not all they do, but they just help bring parties together by highlighting risks, really, and potentially benefits if they require it. The parties, if they ask, hey, is our case good? Let us know. And mediation is a good chance for everyone to get a bit of sense of, from a third perspective, how things are. That's mediation. Discoveries is the other option that could happen at that point. Discoveries is what you really see on TV. It's when lawyers sit on the other side of the table and they ask questions directly, and they often can be a bit confrontational with it, requiring a yes or no answer. It is a chance for your lawyer to really get into the details of the defense or the claim, the statement of claim or the defense, and the crux of the matter, and in essence paint you on the other side as inaccurate, as untruthful, and to really break down the case of the other side. So similarly, if you're facing discoveries, the other side will be asking you questions to make you look like you're lying, that you were lying to your lawyer, that you don't really deserve anything. And they can be pretty exhausting emotionally, but they also could be very satisfying if you get your answers from the other side, pointing to holes in their case. For example, having someone admitting that they took information before leaving, or getting an offer of employment somewhere else at a certain date, and after which date you have your metadata in your office, for example, that you were able to collect information that they took information before they got an offer, for example, or after they got an offer. All those can be used and should be really used as evidence to make or break your or the other side's case. That is discoveries, and discoveries personally are my favorite of the litigation process. We're getting some questions. Let me see if I can answer them. New Brunswick, can't help you there, sir, but happy to try, or ma'am, I'm sorry. Happy to try, just email me, and I will either find you the answer and then connect you with someone, or see what I can do. Another question looks like a termination. Happy to answer, but because this is strictly corporate commercial litigation, I'd rather keep it to that. Then I'll answer some questions. I'm actually breezing through the information. Feel free to ask questions if you have them. Discoveries we talked about. Pretrial motions and motions. Those again are applications that could be brought, or motions that could be brought to a court. They could be done anytime. They are often done to require the other side to do something. So to produce documents, to to produce documents is really, it's production, motions for productions. Sometimes it's a summary judgment motion, meaning a motion to a judge telling them there's no need to wait for trial and we have all the details we need right now to decide on what to do. So there are motions could be used for many reasons. Same with case conferences. This is when you go to a judge and you tell them the other side is not really playing ball when it comes to agreeing to a timeline. So we would need you to confirm a timeline for us that would allow us to move through the court process without being interrupted or without the other side denying what we need to do. These are case conferences and pretrial motions. The trial itself is what happens after that. Trials are what you see on TV. There's examination first, examination in chief. It requires the witness, the first witness would be you as a plaintiff or even you as a defendant, first to give your testimony, first examination in chief. And after that, it is cross-examination, where the other side will ask you their questions. Obviously, that is after your lawyer has presented sort of the introduction of the case, the opening statements, and at the end it would be the closing statements, and then you wait 2, 3, or 10 years to get a judgment. That was a joke. It's 2 years or less, generally less, not 10 years. That is actually all the information that I prepared for today.